Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic is What Has Changed or Not in 14 Years? A conversation with Steve Harris on the development of China's anti-monopoly law. The principal antitrust law in China is a statute called the Anti-Monopoly Law, or simply the AML, which was enacted in 2008. In 2022, exactly 14 years after the AML's enactment, the AML was amended for the first time. In this episode of Our Curious Amalgam, we'll explore the history of the AML and the development over the course of the last 14 years. Joining me today is my co-host, Anora Wang. Hey, Anora.
Hi, Christina.
So who's our guest today?
Our guest, Steve Harris, my former boss and all-time mentor, is a widely recognized leading practitioner and thought leader, particularly on China's antitrust law or the anti-monopoly law. Steve has been one of the few experts consulted by the Chinese officials when the original AML was drafted, and then in the following years, Steve has handled some of the biggest matters in front of China's antitrust enforcers. Before that, Steve also handled numerous high-profile matters before the antitrust authorities of other Asian countries, including Japan and Korea, and published articles on developments of antitrust policies in all of these countries. Throughout his career, Steve practiced in several large law firms, including Winston Strong, where we both worked at. And Steve navigated clients in a wide range of industries, including automotive, healthcare, and high tech. Steve's experiences and insights are valuable to anyone, including myself, who wants to better understand China's antitrust law before and as it stands today.
Great. Well, without further ado, Steve, welcome to the program.
Thanks, Christina.
Steve, I hope to go back a little bit in time, but maybe not too much. Let's start the conversation with something like, maybe 15 years ago, maybe it has something to do about a trip that he took to China when the Chinese government, I think was thinking, or the lawmakers were thinking about the creation of the AML. You somehow got involved. How did that happen?
Pure serendipity. The China Lawyers Association actually contacted the president of the ABA and asked if there was anything dealing with competition law or antitrust law, and if there was anybody who could assist in China's consideration of enacting such a law. And Kai Ewing, who was chair of the antitrust section at that time, got the call from the president of the ABA, and I got the call from Kai. Kai knew I had been active in Asia and in Japan and Korea, and I had spoken on Asian antitrust law issues for several antitrust law section events and had written on the subject, so that my name was picked out of the hat by my old friend Kai. And I was invited to go to something that I didn't know what it would be. I came to learn that there was a Japanese gentleman and a German gentleman who were also invited, both of whom I knew previously. And we wound up seeing the first draft we were allowed to see, the night before a meeting with the Chinese experts and officials. At that time, what is now referred to as MOFCOM was called MOFTEC, and the two heads of MOFTEC led a session the next day. But we saw a very rough draft that was quite different from competition law as the three of us were used to thinking about it. So we sort of threw away our notes that we had planned to talk about and went back to basics with regard to the purpose of antitrust law, consumer welfare model, efficiencies, and the kinds of things that are familiar to you, Anora, and you, Christina, from a U.S. standpoint. and tried to share those views as best we could
Right.
the next few days with the assembly.
Right. So the idea behind that, I guess, was to really to maybe not learn, but to take notes from practitioners from U.S., from Japan and Germany. So what were your tasks and what kind of experiences and insights, particularly the Chinese lawmakers, were trying to lean on and to I guess to discuss and learn from the experts that were consulted?
Well, so one of the initial disconnects with some of the experts and officials was the initial idea that was embedded in the initial draft I saw, that what we call big is bad. One of the provisions in the initial draft
Right.
said that having market power was an irrebuttable status crime, regardless of how one got it. I mean, it didn't say regardless of how one got it, but that is the unstated predicate. So, as I say, my non-Chinese practitioner colleagues and I tried to explain that this would be unworkable in a market economy where if you're Bill Gates, you can wind up with a monopoly having done nothing worse than, making up code in your garage or your parents' garage. So again, as I said earlier, we tried to get back to basics of the fundamental reasons
Right.
that Western countries and other countries have adopted competition laws, the benefits to the consumer, the benefits to firms operating in a market economy,
Right.
what kinds of market disruptions there can be that necessitate or that make an antitrust law useful and helpful in that regard.
Right. Right. Well, ideas like big is bad or big is not necessarily bad. Well, if you look at the debates right now in the U.S., right, sometimes you don't think it's not so much a matter of advance or understanding of the market. Sometimes it's fundamental philosophies, I guess, the lawmakers are trying to lean on. But remind us, so what are some of the most seriously considered or even possibly debated issues for the AML drafters at the time?
Sure. One of them was the conundrum of how to deal with an economy, a great percentage of which is represented by state-owned enterprises. And during the drafting of the law, various factions arose proposing various ways to handle it. One was to simply apply the law to all firms, including state-owned enterprises, equally to the extent that's possible with state-owned enterprises. A second one, the other extreme was also proposed, and it had its champions, which was to not apply it at all, leave the sectoral regulators, as we would call them,
Right.
to regulate pricing or any other activities of the state-owned enterprise. In the end, we wound up with an article of the law that is sort of both and neither, and it still engenders a lot of debate and controversy when people get together to discuss what's right and wrong, or what's better or worse for an economy, an unusual economy like China's, in terms of finding the right balance. And in practice, initially there were virtually no cases against state-owned enterprises. Then that has changed gradually, and in fact now, we have seen a number of enforcement actions taken by SAMR against state-owned enterprises. They are handled differently in the sense that the sectoral regulator is involved, but that's not so different from our telecom sector or our banking sector, where
Right.
the antitrust enforcers in the U.S. have to coordinate with the experts in the sectoral regulator. So
Right.
it works. Doesn't work exactly the same way, but that general concept applies. And I think this is one area that the Chinese officials and experts are still working on,
Right.
and still working out. Of course, China's economy has changed a great deal in
Right.
15 years in many ways. So
Right.
just as our FTC and DOJ are working on the way our economy is changing, and our technology companies are changing, and thinking about antitrust is changing, all of that it is somewhat deja vu to me, having seen it happen in China before here.
Right. Right. And
And
we're
do you
going
think-
go ahead.
Do you think that there was thought given to wanting to have the law be flexible enough to account for changes in the economy, or thoughts about how the economy might evolve in, say, 10, 20 years? Obviously, it's getting amended now, but
Right. Yes, I do think so, and much of the Article 1 and the beginning articles, I would say, sort of a preamble stating the purpose. It's still debated how that should be applied, if at all, in interpreting other more precise sections of the law. So we have seen, first of all, the sophistication and experience of the antitrust officials and agencies in China. And originally, as you know, there were 3 agencies that were later combined into a single agency, current SAMR. And we have seen a tremendous increase in sophistication, use of world-class economics analysis, increase in opinions that explain the reasoning. Initially, that was lacking, as might be expected in a jurisdiction that just adopted such a law. If we consider, looking back at early 20th century case law in America, that there are some pretty bad ringers in there that we have to deal with. Vaughn's Grocery comes to mind. So we all learned about in law school. So China went through the teething pains, and we all discussed these at various, symposia and various writings, and people, including me, criticized certain decisions or interpretations of the law. And I think that was part of the growth, the growing pains of the law.
Right.
But it has improved dramatically in terms of predictability, and in terms of being able to counsel compliance, which was, in my view, almost impossible initially, probably understandably so, given no track record and a fairly vague law. Which is why the book I wrote on the subject often says, we don't know, but here's how the U.S. does it, and here's how the EU does it, which is sort of all I had at the time.
Right, right. So when we talk about the law, it's necessary to also talk about enforcement, right? And the enforcer right now, the main agency, Steve, you just jumped into the acronym, SAMR, which is the State Administration for Market Regulation, for people who are not familiar with. But Steve, you've dealt with more than one agency, right? And right when it was 3 agencies, apparently the division authorities is not quite clear, as one might argue. Would you tell us a little bit about your experience practicing in front of those agencies? Obviously, that's not necessarily the case today, but what are some of the most memorable experiences you've had?
Sure. Well, first of all, I will say that living and working primarily in a jurisdiction with 2 agencies, I told them one was better than 2. And so I guess I implied that one was better than 3, I thought, but I didn't. So they went and did us one better or one worse, and decided to have 3 initial agencies. With the jurisdictional line between 2 of them, between SAIC and NDRC, the National Development Reform Commission and the State Administration for Industry Coordination, SAIC and NDRC, as we called them then, those were the conduct agencies, the agencies that dealt with unilateral conduct and joint conduct. However, the line of demarcation between the two was very unclear. There were cases, obviously, as there are everywhere, that have aspects of both joint conduct and unilateral conduct. There were a few occasions where both agencies took jurisdiction, and I was involved in one of those. And for a while, we were in the middle of a sort of internecine fight, or we were not in the middle of it. We were outside the door in the hall, waiting to figure out who we were supposed to be talking to, and that was unworkable. But the agencies had very different personalities, if I can call it that. Anora,
Right.
MOFCOM, the agency that was in charge of merger review, had an excellent, in my opinion, initial leader, Sean Ming, who really had studied and worked very hard to understand sort of thinking, and from a non-antitrust background, he really did a good job of building a strong team that was faced with very unusual situations, including state-owned enterprises, a locally state-owned enterprise, Guiyang Juice, for example, comes to mind.
Right.
And MOFCOM and its team, I think, in my mind, get the blue ribbon for having worked harder than the other two to sort of reach out and understand the thinking and the scholarship in antitrust and economics, and understanding market economics as needed to consider the possible harms or lack of harms from a proposed merger or acquisition. NDRC and SAIC came from very different backgrounds. MOFCOM came out of the Ministry of Commerce, which I guess in its genes was assisting with a market economy working, or at least an economy working, and commerce going forward. NDRC had a history of being in charge of price regulation. Some of us would see that as just the opposite of competition, of letting the market determine the price. So NDRC was in the business of telling companies what they had to charge and punishing them if they charged the wrong amount, which is a foreign concept to those of us here, except, if we think back in our history, a few times we've had, during World War II, et cetera, we've had a few times when the U.S. government tried to get in that business and it didn't work so well. But NDRC brought that, and a very, very much a strong law enforcement ethic,
Right.
and self-image to its work, and therefore the proceedings before NDRC were always adversarial, sometimes exceedingly so. I got threatened with being thrown in jail in China for passing my client a note in one meeting. So,
oh dear.
Nothing happened. I didn't go ballistic, and the temperatures came down. But it was a very going and taking a client to see NDRC was very different from taking a client to a meeting at MOFCOM. Let's just say that.
Right.
And SAIC was, I guess, somewhere in the middle. Initially, SAIC's quote unilateral conduct job made it a fairly limited, in part because NDRC defined its remit more broadly than I would just reading the words describing the division of labor. And second, there's a pecking order in these three agencies, which I learned at an event that I hosted connected with the spring meeting many years ago, where I was always trying to get the heads of all three agencies to come and speak at an event for the antitrust section. And we finally got 3, but we got the head, Xiangming of MOFCOM, but we got the 2 deputy heads of NDRC and SAIC. Mm-hmm. And stupid me, I was, I made up the speaking agenda, and since Xiang was the head of an agency, I was going to let him take pride of place and go first. And he and his ever-present, expert and interpreter, who Anora, and we all know, Roger, came and said, "Steve, this won't work. You idiot. The NDRC, anybody at the NDRC outranks anybody at MOFCOM." And this sort of exaggeration, I'm sure, but that was how he put it. And so he corrected me, and we saw that in dealings in matters that touched on the jurisdiction of 2 or 3 agencies at once.
Right.
Where if there were any question, NDRC was going to call the balls and strikes and decide who did what and who didn't do what.
Right. A couple of reactions. I think, for your definitely some of the stories that you just told are memorable for sure, and then it matters where the agencies are coming from, where it's structured. Even now, with only one agency, whether a particular bureau responsible for merger review is considered a department level or a bureau level, it matters a great deal. So we're seeing that a little bit. Even now, when there is only one agency, right? And then we begin the show by talking about amendment and the new agency, and with the new law, the agency is also promulgating legislations trying to interpret or help or guide business community to better comply with the law. So I think that probably is a good segue to our next main topic. So I think with the new amendment, the new law, the newly amended law, and then the newer and updated legislations coming, obviously some of that are still the public comment stage. But have you observed some high level trends or big picture changes?
Well, first of all, the combining of the 3 agencies was a watershed event, in my opinion. And it gave the combination of the antitrust agencies, the new antitrust agency, a more direct line to the state council than at least SAIC or MOFCOM had. NDRC had a fairly direct line, but the new agency, I think, is seeing clearer guidance, and someone up at the state council or standing committee level, I don't know, it's all a mystery, but somebody up there seems to be giving clearer direction, and we don't see as many cross wires or inconsistent indications of what is required and what is forbidden, as we did in the earlier days. I think the amendments are intended to further improve that and make the face of the agency and the purpose and goals of the agency clearer, so that businesses dealing with the agency do have a better concept, a better idea of what's expected of them and the extent to which they can rely on the guidance or statements. In some ways, I think we're seeing the emergence of something comparable to what they call in Japan administrative guidance, which is a unique sort of relationship between firms in the market and an antitrust regulator. That is a much more embedded notion, where the agency stays much more connected to the company's activities, and the company relies on guidance more, I guess, frequently and and more closely than we would see here. You see some of that has increased in the European Union as well on some topics. In one area that I think continues to be a hot topic, the intersection between intellectual property law and competition law, these amendments are intended to help with understand this and whether or not China has an essential facilities doctrine, and if so, when it applies, that remains a thorny issue. But I know that China continues to grapple with this, and of course it amended its patent law not too long ago, also in part to deal with these competition issues, constructive, compelled licensing, that sort of thing.
Right.
That we run into, and we haven't solved that anywhere on Earth, I think, yet exactly the best way to deal with those issues. But China's wrestling with it more directly and more openly now. In the past, Article 55, which, as you know, Anora is the article that initially said, it's a little bit of a schizophrenic article. It says lawful use of IP is okay, but unlawful use of IP is a violation.
How helpful.
Yeah, to me, could have been more helpful. But as you may expect, that was the result of not being able to really resolve the debate between various factions on this issue and various interested parties on this issue when the law was enacted, and that this was really just a way to punt the issue down the road, in my mind, and it resulted in some very interesting cases that I worked on, and I was required to try to understand that and its and the guidance given on that in regulations for clients. But we still need more guidance in that area, and I think we're getting there slowly. I'm hopeful that we are.
We try to have this conversation on a high level because many things are still in the works. The legislation are still being commented, and as Steve pointed out, well, I guess I could also add to that, like the U.S. antitrust law. Sometimes we call that constitution of the economic laws, right? A lot of that is more in here it's case law, and then in China it's going to be legislation and actual enforcement actions. But I guess one more high level question. Over the years, have you observed a greater level of convergence, right, of the Chinese anti-monopoly law and the competition laws of other jurisdictions? But are there areas that's still sort of like a holdout areas, like China is still going to consider it very much independently and very much differently from other jurisdictions? We talked about a state-owned enterprises. Maybe that's one instance. But what other observations that you have had?
Well, I think there's a tendency in some instances for the enforcers to use the law, and this isn't unique to China, but it may be that China's a better example, or more frequent, gives us more frequent examples of this, where the law seems to be used for the government to sort of send a message to companies. Mm-hmm. And to require in remedial decisions or orders actions that seem unrelated to any concern for an impact on competition in the marketplace. We have seen, for example, a number of investigations into distributor pricing in certain sectors of the market, where it seemed that the goal, to me anyway, it seemed in a number of these cases, the goal was really for the government to restructure mm-hmm. the distribution structure, and it wasn't really a concern about pricing at the fundamental level. it was a desire to move away from some of the early inefficient atomistic distributorships and structures that came about when local governments were so active in attracting foreign direct investment,
Right.
and large companies had to sort of get find a distributor, an agent on the ground, maybe in each province, in each tier 1, tier 2, tier 3 cities.
Right.
And in some cases, this has come as a relief to large companies who have wanted to restructure those sort of out-of-date distribution networks. In others, it's caused significant issues, and the concept of contract law exists in China too. So being told to sort of redo this or to do something, the only way to get to the goal that the agency insists getting to is to end contractual relationships prematurely. That's a conundrum I've had to live with in a few matters where we would not see anything like that in the U.S. at least, in terms of anybody at DOJ caring how a pharmaceutical company or a healthcare company or whatever picks and deals with its distributors, how many distributors you have, where they're located. That's your business, and if it's not working, you figure it out. So we that may, I guess, I would put that to some degree in the administrative guidance bucket. That in the back of your mind, as a U.S. practitioner, you want to say, "Wait a minute, you're an antitrust regulator. Why are you involving yourself in this hard enough job regulating antitrust as we define antitrust in the West?" But it's not it's not unusual, and it was not surprising in the sense that it came from an entirely state run and state planned economy not that long ago.
Yeah.
It's actually funny when
I went to China in the early '80s, and it was a very, very different place, a very different economy. So they've moved a great distance in the direction of a market economy.
I remember growing up, and as the economy was starting to open up in China, my relatives would say, I'd ask, is it socialist? Is it capitalist? What is the economy? And they'd say it's China's version of capitalism. And I think it's fair to say that the AML is and its enforcement is China's version of antitrust enforcement. So we don't need to go much further than that. Anyways,
no, the statute says it's a socialist market economy, and I still am figuring out what that means.
Exactly. Well, Steve, it's been wonderful hearing a little bit more about where the AML comes from, your participation in its evolution, and obviously it continues to change today, and it will. And we'll look to ongoing guidance that comes out and enforcement actions as we understand how the new AML will be interpreted. But before we let you go, Steve, we do ask all of our guests a couple of questions. You have a very interesting sort of career trajectory, and would love to hear your advice that you have for young professionals who are interested in doing what you do.
My advice would be to take challenges as they come. Don't pass up opportunities, even if they don't seem to be in your primary lane or they don't seem to fit your own concept of what your career is going to be. So try things out. Don't be afraid of, strange new challenges that come across your desk. Embrace them, learn from them. In my case, to a certain extent, international antitrust practice came to me. I didn't come to it, and it was, as is true of all practicing lawyers, it was a client with a problem that wanted fixed. And it didn't care that it was a little different from the kinds of things that U.S. antitrust practitioners normally see. It had a business problem, and it happened to be outside the United States. And they were good enough to rely on me to assist them, and I, with trepidation, jumped in the deep end of the pool, and I've enjoyed the swim.
One door opens another. And now for our final segment, what we call the Curious Hat.
And now it's time for the Curious Hat!
So Steve, can you pick a number 1 through 10?
7.
7. Tell us about a teacher who had a major influence on you.
So, I was a physics major in college, and Carl Sagan was one of my professors.
Very cool.
His course was not named this, but his course was really Critical Thinking 101. And among other things, he brought a magician, the amazing Randy, who just died a couple of years ago, fantastic magician and thinker and writer, into the classroom to teach us that the people most easily fooled are the most intelligent, most educated people. Because our brains, we have trained our brains to run across, down nice little paths and predetermined paths, and magicians and conmen and, sometimes opponents in litigation, etc., rely on our brain continuing to run down those paths, and just teaching me to think critically and to question a priori assumptions. I still am so grateful for Carl for having given me that.
Well, what a great lecture
insights.
topic. Bring in the magician.
Right.
Well, Steve, thank you again for your time today. And for all of our listeners, thanks for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.